Frauditor Mania. I love you so much. Thanks. You are so awesome. You are super. Eagle Nick says that. You are super. And I thank you.
Are you die right now?
Yep.
La 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 la. I don't care what you say. La la la.
Hi.
Hello?
You're triggering me. You're trying to get me
That's
emotionally active.
I'm not trying to. You're doing it to yourself.
The cameras,
Yeah,
witness.
that's fine. There's lots of witnesses. We're in the middle of the public.
You stepped in the puddle, buddy. Your sock's gonna get all wet. Your sock is all soaked and wet.
Oh, what an assault.
Fuck you up. Say my mom again, bro. Say my mom again. Say my mom again, bro. Say my mom again. Say it again, bro. Say it again. Get the fuck out of here. Fuck out of here. Wait.
Are you serious right now?
Yes, like I can stay out here with my camera and stuff.
Certainly.
Yeah. Oh, my name's Russ. Your name, ma'am? Wow. Holy cow. Such rude and unprofessionalism. Or, I mean, orally or in writing.
I'm gonna shut this window.
Can I-
I'm not agreeing to be in video.
Can I do an open records request? Please?
Let's go.
Don't you touch me. Don't you put hands on me. This is a lawsuit, sir.
Okay.
Everybody see what's happening? Look at this.
They're wrong.
Quit touching my penis! Quit touching my penis! Quit touching my penis! It's not. It's called a public easement. Quit trying to fucking bully me. I know my rights.
Stop. Come on. You're like an old man. And I'm an old man.
Sir, that's not nice of you, sir. That's not nice of you.
Go ask her. Go ask her, by the way. You cocksucker. Hey. Go ahead. Yeah, go ahead. Go ahead. Go ahead. Go ahead. Go ahead. I'm not resisting. I'm not resisting. Go ahead. Go ahead. Go ahead. Go ahead.
We're making holy honor. That's how you throw your kid, right? It's a First Amendment right violation. I'm a press.
Get the f*** off me. Call the police.
No, you wanted to stand there and hold your cell phone in my face is what you wanted to do. Yes, you do. Take your cell phone and go and make your complaint, okay? Okay.
Those are my fucking court records on the floor.
Get this off my wrist!
She has a broken back, by the way, too.
You think that me wanting to know where to find you has anything to do with YouTube? You're sadly mistaken. Your name is going on the lawsuit.
You know, I find it interesting if you think about that introduction video of my channel, because it starts with so much love and then ends in so much hate. You have Eagle Nick, proud in Armenia. I love you so much. So I cough. I love you so much. To then being threatened to be sued by for public safety. Oh man. It's it just goes to show you over the year, you know, you have some fans of the channel, you piss off some of the channels. That's okay. Found out today, bigger channels are actually stealing my videos, so I'm gonna let it go. I text one of my buddies, was a bit annoyed by it, but I'll let it go. I'm not gonna be that person that copyright strike when people are clearly stealing my videos unedited, but you know what? It's fine. We'll let that go. Good evening. How is everybody on this Wednesday? We're not going to be here long. This stream actually was something that I thought of during the day today. Pacifically, if we're talking like Mr. Brooks. As a lot of you might be aware when my channel first started, I was, and I still am fascinated at the Darrell Brooks trial. And I said, you know what? Let's actually reminisce. Because guess what? He's a sovereign citizen. So therefore, it's fully 110% applicable that we could watch a big chunk of his trial on our channel for tonight. And if you guys followed that trial, you recall the arrogance, the bravado, the smug know-it-all, whatever you call that, you know? And it's so satisfying to know that he's rotting in a jail cell after all he did. But before we hop into that, say a quick hello to everyone that's here. David, I know David Persons was first, but I can't see his comment, but whatever. Great to see you, David. Greg, good evening. Pardon me while I blow my... Joe always wins with the names. I love it. Bookie Worm, aka Eagle Nick Enthusiast, welcome. Cyberax, great to see you here. GJM, big fan of your content. Well, thank you. Thank you. I appreciate that. We have a lot of fun on this channel. Lovely Lorez is here as always. Great to see you, Lorez. Oh no. KC, cooking video isn't appealing at first glance. But my fiance told me. She told me one of the things that won her over was the fact that I can cook. Because many guys cannot cook, especially when you come from a big family. Like, I have 4 sisters, right? So people assume I don't know how to cook. No. Mama said she's going to raise a boy that can cook. So, who knows? It might interest some people. I mean, so KK and I, we were talking. She can the future of the channel, right? She said she would like to put out content with me in the future, but it's not going to be anything about this. So there are bigger channels that kind of have like a direction that they go in, but then put random stuff in as well. One of my favorite channels, I probably mentioned it before, a guy named Atomic Shrimp. He's a guy from somewhere in England or British. He's British or whatever, wherever. I don't know where he's from. But he talks about scam baiters, like they send the emails out. But then he also does budget challenges with his wife. And people like both. People are like, oh, the scam baiting videos brought me to watching your blogs with your wife about budget cooking. And people love both. So maybe something like that. I don't know. Hey. No, I do not only know how to heat up Philly egg rolls, Joe. Come on. You know, Mike, I love his channel. I can binge watch his videos. His videos are awesome. You're an expert on that trial. There we go. Speak of the trial. Grounds. MC Dilly Gav, good evening. Oh, Laura. Hey, Fraud at Mania. I love your channel. Aw, I appreciate you guys. Thank you. Guys. I appreciate everyone's support of my channel. Like I said, we have a lot of fun here. You've been watching budget challenges. His budget challenges are good. The one challenge, my favorite, is when, oh my goodness, it was he did like 4 pounds in 2 days. And it just goes to show how versus like purchasing food in the UK versus purchasing food in the US, how different it is. Because food is so expensive here in the US. 4 pounds would be like $5, I'd say, give or take. There's no way you're going to be able to get meals for 2 days unless you're going to a dollar store or if you go to a supermarket where they specify and buying loose items. So the way he thinks outside the box on his budget challenges, I really like that. Shows how creative his mind is, just in general. I'm getting a whole lot of messages. Who's messaging me? Okay, I'll deal with that later. A couple other comments I just saw. Mark Stewart, good evening. The Eva, who did I see? Eva's toast tax. The cheese tax. Anyone remember that TikTok? The song's always stuck in my head. Hey. I don't just boil water. You know what? I'm tired of you guys. Now I have to do a video. I absolutely have to do a video because you guys think I'm joking here. Oh, GJM. You're talking to someone that's from Philly. We don't, well, Pat's and Geno's, we don't go to Pat's, we don't go to Geno's. Tony Luke's is okay. If I had to choose between the three, I'd take Tony Luke's. But you got to go to the hood, North Philadelphia, Broad and Erie. It's called Max. Maxx. That's the cheesesteak spot in Philly. Quote me on that. You go there and say, Will sent you. They have no clue who I am, but that's where you go. Pat's and Geno's, that's a tourist trap. Overpriced, not good food. Not good food. Tony Luke's is okay. Let's just see real quick. Cyber, I can cook anything. It's not safe to eat, though. Exactly. Oh, my goodness. Food in the U.S. versus Canada. Exactly. It's such a difference, and it's something, well, because he was saying one of his videos, it's like food, it's so much cheaper here, but property, like property tax, mortgages, gasoline is so much higher there than it is here. So he's like, it balances out. So it is what it is. Really? So's my dad. So is my dad. I lived in West Philly for about 4 years, and I'm moving back to Southwest probably in a couple of months. So there you go. Are you GJM? Are you Philly based too? I ordered it with. You ordered it? Hey, go for it. Okay. All right. You know what, you guys? Food might be something that we do. We may have to do something where we're cooking or we're talking about food, something like that. Well, look. It's exactly why. The obesity rate among young children, even adults, because portion sizes are gigantic. If you go to a restaurant, they give children way too much food. Adults, they give way too much food. We, as adults, we're so used to eating so much. So the U.S. versus that's why the U.S. is one of the most unhealthy countries in the world. For that very reason. Yeah, been to Philly. Philly's awesome. That's the spot. If you come to Philly, Broad and Erie, go to Max, right on the corner. Big place. Best cheesesteaks you'll get in Philly. Best cheesesteaks. Okay. No. No. You're Will from Philly. I have friends in New York. They quote that all the time. Like, Will, where are you from? Well, I'm from Philly. I'm from Philly as a kid. Oh, West Philly. Shut up. No. All right, guys. All right. Let's talk about Darrell Brooks. You guys are experts on Darrell Brooks. Let's talk about Darrell Brooks. So for me, the video that I want to watch, for those that are familiar with the trial, is this 50-minute rant that he goes on in court. Now, I need you guys to understand something when it comes to the judicial system. And again, like, I'm not, Will's a security guard. I work in the legal sector for the last 4 years. I know what I'm talking about. I go to court all the time. This trial is so unrealistic, but it also proves why. When they say, do not go to court unrepresented, this is an example. Darrell Brooks, I believe, was someone that watched a couple of episodes of Law and Order and said that, hey, this lawyer thing isn't that difficult. So, well, you know what? That's a conversation that we're going to have, GJM, in the future, because they don't make any money. They don't make a living. They live off tips. But we'll talk about that another time. But he demonstrates to the world why, again, you always have a lawyer when you go to court. Now, the big thing in his case, and if you don't know, but you should know, the part of why this was on my mind was because a similar tragedy took place over New Year's. He drove his SUV through a parade in Waukesha, Wisconsin. A Christmas parade where there were families, children walking the streets and he plowed his car through the parade and unalived 6 people, harmed 70 people. And it's appalling to me that this even went to trial. There's so much evidence, but his arrogance is part of the reason why he wanted to represent himself. And he's going to bring up some very interesting arguments in this rant that he goes on, which is why I want to play it, and I want to kind of interject my thoughts, because it's ridiculous. It's ridiculous. And again, this does not happen in court. No judge on the planet would let a self-represented litigant go on a rant for 50 minutes straight. But there's a reason why the judge allowed that. And people that watched the trial, they said that, oh, the judge was too lenient. The judge wasn't hard enough. The reason why the judge was that way was because she did not want there to be any grounds for an appeal. And that's part of the reason why people represent themselves, because they think that because they made a mistake here, there's a mistake there, the appeals court could say, hey, he deserves a second chance to represent himself or to go back to trial because of the mistake that he or she made. So I'm just going to start this video. I'm going to play it. I don't want to watch it here for a whole 50 minutes. I'm going to play it at 1.5 speed. Let's just start with this video and have a look as to what led to this rant. So let's get started.
Record, then appearances are as they were before. State have the next witness available. Yes, Your Honor. All right, let's bring the jury back up.
Don't consent to being called by the name that this court chooses to identify me by. I'm going to state for the record that I'm here as a third-party interviewer on special appearance on behalf of my client.
Now, again, that's the sovereign citizen lingo. Like, I don't consent to being called the name that's on my birth certificate, driver's or state ID, social security card, all that. Oh, I don't consent to being called that name. Okay. And as Judge Darrell does repeatedly, she says, your objections noticed is noted for the record, but it has nothing to do with the case. This whole I'm here as a third party making an appearance. Now, I don't know the sovereign citizen script well, but that's something common that they use in court. Oh, I'm not the person accused. I'm representing the person accused as a third party. It doesn't make any sense to me. It's why sovereign citizens fail, because it's a nonsensical argument. Because guess what? In the court of law, if you are not the person, if you're not a licensed attorney and you're not the person that is on trial or the person that is engaging in the litigation, you cannot represent someone. A parent, here's something you guys might not know. Did you know in the court of law, a parent cannot represent a minor trial in a court proceeding? You might think, well, the child can give consent to the parent. No. I've seen parents try and file litigation and say, I have power of attorney over the child, so the case is technically against the child, but my name's on the documents. Some small counties will get away with that, but legally, a parent cannot represent a child. So how would this argument then that the sovereign citizens make that a person could enter their appearance as a third party to represent the accused if they're not a licensed attorney? That's why, like in this case, Judge Darrell just says, your objection's noted, and then just ignores him. So.
Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Let's bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown.
And again, subject matter jurisdiction. Interesting fact about the trial. She addressed it twice. She made a written decision, I think on the third or fourth day of trial. He refused to read it. Another copy was given to Mr. Brooks, Darrell Brooks, which he ripped up in court. So he continued to say it hasn't been proven or it hasn't been addressed, but it was addressed. That's why the judge doesn't indulge in it in any way.
Any verified proof that this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this
please.
the military
All right,
power?
can you please take the jury out? Thank you.
Now, part of his tactic with Brooks was the fact that every time the jury would come out, he would always make these statements in front of the jury. When you have a jury trial, the judges do everything in their power to make sure that that the jurors are only focused on the facts of the case, being through testimony, through cross-examination, whatever the case might be. Literally, Brooks kept trying to make it sound as though that the court was hiding things from the jury. That's why he would stay silent before and after the jury wasn't present. But the moment the jury would come in, then he would start throwing out these lingo. Oh, can you show that you have no bias in this case? Oh, can you prove that you have jurisdiction or prove that you have the power? Blah, 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 blah. The soft sets do that so that they can't be held in hail. One guy actually tried to turn in a sheet of paper with his name on it to serve his jail. I heard about that. How stupid is that? And exactly, he was trying to cause a mistrial. Exactly. He was trying to get the judge to say something, do something. The real thing was he wanted to delay the trial, that she would hold him in contempt for like 7 days, delay the trial. And she wasn't playing that game. All right, let's play on a few minutes when he really starts rolling, so to speak.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait until the jury's out, please. I ask that you show that.
Hi, Will. No close. Why no closed captioning? You know, we can do that. We can absolutely do that. Absolutely. Just for you, Paul. La la la. I don't know. I've never seen you before here. Welcome. If this is your first time, but yeah, we can get closed caption for you guys.
I will.
Thank you. Everyone else, you all can be seated. Ms. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking,
On what legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office.
Okay, two things just with that statement alone. And I agree with that, GJM, because this set precedent that you could be charged with capital murder, and you should represent yourself, even if you have no legal training whatsoever. I agree with that. And it did harm the victims, having to put victims on the stand and having him cross-examine them. We're going to watch the end of one of the victims that he cross-examined, who clearly was terrified of him. And the judge not cut that crap out that he was trying to do at the end, which we'll get to. But there's two things that I want to mention with that statement he just made. And I'm just go back and just play it again. It's not far.
He's certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office.
I want to make something incredibly clear. Number one, no judge on the planet will provide a certified copy. I'll be honest with you. I don't even know of any judges that here or anywhere that will provide a certified copy of their quote unquote oath of office. Not oath. He keeps saying the word oath. OAF. I need your oath of office. Sure. But no judge is going to provide that because no judge has to prove that they have the power to rule in your case. That's not how it works. And he's also talking about, a certified copy of my court docket sheet. A docket sheet lists the activities and the history of a case. Pre-trial conferences, memorandum of laws, pleadings that have been filed, all that. You don't get a certified copy of a court docket sheet. And even if you did, what purpose does it gain? What relevance does it have to your case? There's absolutely none. Yeah, exactly. The state statute says that your oath of office needs to be certified. Shut up, dude. Do you you know what? Because she was on her way. So I've read some articles about that. And the consensus was she was on her way to being elected to the Wisconsin Supreme Court. I wouldn't be surprised if because people said that she didn't pull the trigger sooner. She let this go on too far. It's a possibility. I don't know. I don't know. But anyway, so it just goes to show again how much of a non-lawyer he is and how he's absolutely clueless with how the judicial system works. No judge is required and is going to, even if they were required, no judge is going to. If I go to court and say, Your Honor, give me your oath of office before we proceed on, they'd hold me in contempt on the spot. But why you need a certified copy of your court docket sheet? Answer, you don't. I mean, tell me if I'm wrong. If I'm wrong, tell me. Tell me what relevance a certified copy of a court docket sheet. Tell me what that does for your hearing. It does nothing.
Which you are required to show if I ask for it.
No, she's not. Quote the law. Like I say with frauditors, show us the law where it states that a judge is required to provide a copy of their oath of office. I said oath, OAF, their oath of office, if someone asks for it. I'll wait. So if someone can show me a law, I'll send them $20. Tell me where that's stated.
I've brought up my Sixth Amendment constitutional right that has been pretty much discarded. And that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim.
And again, it just what Dr. Dave says, where do these fools come from? They come from their mama's backside, apparently. But it's such a nonsensical, uneducated argument. Oh, if it's an entity, if it's the state of Wisconsin can't bring a claim because they're not a living, breathing human being. Let me ask you a question then. Who gets on the stand to testify on behalf of the state? Living, breathing human beings representing the state through the entity, which is the state of Wisconsin. And the thing is, that is such a simple concept to understand. And he dragged it out the entire trial to make it like, oh my goodness, this is so egregious. My constitutional rights are being trampled on because I can't face my accuser. Literally, you are facing victims, people that have been run over by you, people that lost family members, officers that tried to hunt you down after this horrific incident took place. And I agree with this. He didn't argue any facts of the case. legal violations, nonsensical loopholes. Because, I'll give him credit. He was smart enough to know that he had no chance arguing the facts of the case, even when he tried to argue the facts of the case. Oh, well, the person driving the car, what did their hair look like? Because he has short hair now. He had long dreadlocks. They're like, oh, well, if the person had long dreadlocks, it couldn't have been me. Do I have long dreadlocks now? Like, but the nonsensical loopholes, like, oh, technically the Sixth Amendment says I have to face my accuser. The state of Wisconsin isn't an injured party in this case, so therefore, blah, blah, blah. It's nonsense. Absolute nonsense.
I requested for the complaint to be provided. The complaint from November 23 of 2021, the amended complaint from November 29th of 2021, the second amended complaint from January 12th of this year, 2022. I have yet to see those.
You know what that was? I'll tell you exactly what that was. It was a delay tactic because his goal was just to stall the trial as long as possible and potentially, I think, possibly even get the state to withdraw. You know, that's the whole contempt thing. And then that would be used for appeal. He would use that on appeal. Oh, I was wrongfully held in contempt for trying to argue my case. That's why. I think that's actually really clear. And he's mentioning now he wasn't provided a copy of the complaint. Again, I thoroughly believe that's BS. Number one, the case, all the files of the case were handed over to him when he decided to represent himself. A copy of the complaint and the amended complaint more than likely were in there. If they weren't, because he's taking over the case, it's his responsibility to obtain copies of the complaint. And he's talking about, oh, my certified court docket sheet was a copy of the complaint was listed on the docket. All I had to do was pull the docket, upload the document, and he would have had the complaint. But he's trying to blame the judge as if the judge is the one responsible for him to defend himself in a case, in a trial rather, that he pushed to represent himself on. It's dumb. It's just dumb at this point.
There was no record.
I'm going to play on for I want to get a few minutes into this because you will notice that his arguments do get a bit repetitive, but the mind-numbing stupidity behind some of these accusations is mind-blowing to me.
Bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor, I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been timestamped. I haven't got the original copies of any of them, which I'm supposed to get.
Not true. Not true at all. Sometimes when you file a document, they will give you a copy, but many times, many municipalities will keep the original documents that you file because if it's a signature, they want an original signature, so again, he doesn't know what he's talking about.
And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been.
And that's why the judge told you when you said you wanted to represent yourself, sir, you're not an attorney. She went to great length to tell and warn you that these very issues would arise because you're not an attorney. She said, you will not understand proceedings. You will not understand language. You will not have attorneys there to help you. It is a bad choice to represent yourself. And he said, I don't care. And now look what he's doing. Complaining at the fact that he's representing himself and doesn't understand. And I'll just say this. He kept saying, I don't understand the nature of the charges. You ran over 65, 70 people. You unalived 6 of them. That's the nature of the charges.
Provided in my discovery. They haven't been provided to me by being brought to my pile where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just Bar Association members, or do they have state-issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even...
Again, not required. Not required whatsoever. Especially the fact that these are people from the district attorney's office. This is the district attorney and 2 ADAs. And he's saying that they have to prove that they're actual attorneys. Like they're imposters or something like that.
Even sure if that was even recorded in the docket sheet. There's so many things. And Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the 3 that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where, Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive, or...
I like how he brought that up, because now he's trying to say that the court would remove him when he was trying to make valid arguments. No, the court would remove him to the second courtroom when he was disrupting the judge, where the judge would try and put things on the record, make rulings, and he would disagree with the rulings. Every attorney disagrees with a judge. They just don't start screaming at the judge, telling the judge that they're engaging in judicial misconduct simply because the judge rules against them. That's the point. But he's saying, oh, well, your honor's being biased because anytime I try and make a legal argument, you say I'm being disruptive and moving to... That's not what happened here. That's not what happened whatsoever.
Or causing a problem when I'm merely seeking understanding because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter.
I'm sorry. What is an oath, guys? What's an oath? I'm sorry. He keeps saying it, and it's like, what is an oath? A loaf? L-O-A-F? What's an oath? This is your oath. Your oath, Your Honor. Oh my God. I don't get it. I don't get it. I don't get it.
And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything. Which you stated for the record, a non-responsive answer. A non-responsive answer is an agreement, which will be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering.
And David brings up a good point here. The whole no injured party thing is beyond asinine. 99% of all statutory laws created to prevent injured parties. It's the same thing when frauditors say that, oh, I can... Hold on. It's one of those things like when frauditors say that, oh, no victim, no crime, no victim, no crime. I can drive a car drunk and it's legal because I don't hit anybody. But it's to prevent there being injured parties. That's the point. And the injured party, as David says, is all of the citizens of Wisconsin and those that have been harmed because of him driving through the parade. It's nonsense. And also, it's not a tacit agreement. It's a tacit agreement. He keeps saying it's a tacit agreement. Are you making a tacit agreement? Tacit. T-A-C-I-D. Right? Or T-A-C-I-T. I'm sorry. Tacit. Are you making a tacit agreement? It's nonsense.
I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in evidence any unrevealed contract.
His argument was, oh, the judge is making a tacit agreement or tacit agreement, saying that it's an implied agreement to sabotage his case. That's in essence what he was trying to accuse Judge Darrell of.
Has that been provided to me? Have that been placed in evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth in their duty, in their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times, only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that.
Which again, that's 100% a fabrication. I guarantee you that the state said, look, these are going to be this would be what we would offer if he doesn't want to go to trial, because the rule of thumb is in a case of this magnitude, don't go to trial. Settle. Resolve it before going to trial to waste tax dollars and precious time. He just was so lazy that he did not go through the documents or the record or even confer with the prosecution to know if there was a plea. GJM says this rant should have been stopped. Again, as she will state later on, she goes above and beyond to ensure that he doesn't say, oh, I didn't have a chance to argue all the facts of the case. But as this goes on and on, I agree. Maybe it should have lasted half the time it did, because he gets really repetitive at about the 22, 23-minute mark. And per special request, somebody wanted to come up because they think this is an interesting conversation.
Oh, it is an interesting conversation. This is cool. And Darrell Brooks, one of the problems with him, hi guys, how's everybody doing, by the way, is that he kind of quantifies and exemplifies everything that's wrong with the sovereign citizen movement. Everything. I mean, he's just a walking textbook of soft sit nonsense. He really is.
Yeah, it's all nonsensical. That's the thing. It's all nonsensical when you think of it logically. And soft sits believe they're crap, quite frankly. They believe everything that they say. So,
and the whole thing about, the injured party thing, like I said in the chat a minute ago, 99.9% of all statutory law, for that matter, all marine law, military law, any law, is to prevent people from getting hurt financially, physically, emotionally, mentally, spiritually, however. And they don't get that. They think as long as they get away with it, it's not a crime, which is just frightening.
Frightening, yeah. Goes to show you how many people are actually out there that potentially could commit a crime that could potentially harm us for that very reason, because they think that, oh, well, if I don't harm anyone, then I didn't commit a crime.
And if you really want to see an aggravating, well, I found it aggravating experience, go watch the video of that guy who was trying to convince the judge that he had already tried to turn himself in because he went and he turned in a piece of paper that had his corporate name on it. And he was going to surrender the piece of paper so it would serve 30 days for him. And the guy was serious as it could be.
I gotta find that. I'm gonna find that. I might play that later on. That's
okay.
it.
That one. Ugh.
Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney.
That's not what that
means. The court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brought to my housing unit on the 29th of September, which trial was scheduled, that would be Thursday, which trial was scheduled for Monday.
Hey,
how can I possibly go through all that? All the paperwork, all the digital.
Just as an explanation for people who don't know what he's talking about, when he said pro pre, what he's talking about is the Latin phrase in propria persona, which means
pro se versus pro per. Yeah.
I just wanted to clear that up. But he's talking about in their own person versus pro se, which is representing yourself. There's a big difference between the two. Pro se literally means in one's own behalf, while propria persona means in their own person.
It's the same thing. It's the same thing.
Well, I mean, as far as being there is, but he's trying to imply that. If I follow it right, he's trying to imply that because he's there in his own person, that it's not him, and that he's not the corporate entity that they're trying to charge or something.
Well, that goes back to the whole I'm a third party intervener in this matter. So I agree. That's exactly that's what he's trying to prove, and it's like, I don't know.
But the pro per, I just want to clear
things of that nature. How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that
the court was aware that you were not prepared. That's why they told you to let your attorneys represent you, and you refused. Did you ever see that video, David, where he's in court and the judge is pleading with him to let the attorneys represent him?
Yeah, I saw that one, and he just wasn't having it. And I thought Judge Darrell, man, she's my hero. She got handed an impossible situation, and really did pretty well with it. I thought she handled this case incredibly well. She wanted to make sure that there was nothing in the record that he could come back and appeal, and that's why she let some of the stuff go on that went on,
like this.
Yeah, like this nonsense. I mean, she was letting him bury himself. She really was, and she did a great job of it.
Should be an adjournment, at least at the minimum. It should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear base.
There's no way this guy could have been ready for
I
a
have the
trial.
right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor?
Yes. Everyone that's gotten on the stand to testify.
Yeah, every single person in that room is a part of the injured party. The state of Wisconsin that you tried to assault and kill. by mowing down all those people.
Well, so and here's the and GJM brings up a valid point. He wasn't a sovereign citizen, and he did say at one time in court that he was sovereign, not a sovereign citizen. And there was an interview that someone did with his girlfriend Erica Patterson, and she said that he never just put on those type of arguments until they got to court. A sovereign citizen argument. So someone probably said to him, hey, if you want to get out of this, this is the language that you use.
And it looks like he probably just went and got some, he just got a bunch of the basic sovereign citizen phrases and started running with it.
Well, clearly, because anytime he used a sovereign citizen statement, if you notice, he starts reading from a piece of paper. So, just an alarm going off in the apartment above. I'm concerned. It's been going on for like 10 minutes now. But if you notice, he's reading from a piece of paper. I'm here at a third-party interview. I accept for value whatever he says. So I agree.
The exception for value thing was ridiculous too.
Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who?
I think I can list 70-something people.
I have the right to put the judge on notice of my intent to appeal. And any ruling decisions during the case. You stated for the record that I would have to wait until the appealing process, but my right is that I can raise that issue.
Did he file any appeals in limine?
I don't think. I think he tried. I feel like he tried to do it orally, like during the case, but I don't think so.
Okay, I kind of wondered if he actually tried to do it in limine or not. You might want to explain what motion in limine is for everybody who's not a law person. Well, you might want to explain what a motion in limine is real quick. Like he tried to appeal during the trial. He tried to.
So it's like, how can I mix? I mean, it's if I even can explain it properly, it's like when you file before the trial a motion to make sure that specific arguments are made and specific arguments are avoided, so that the evidence is clear cut in essence.
Yeah, basically. An
So
appeal
it's
refers to an appeal that's filed regarding a ruling made, like in a pretrial motion, or sometimes during the trial, if they don't like, if they think it really damages them, they try to go to the appeals court while the trial's still happening. That's happened before. That happens in death penalty cases sometimes.
Yeah.
But
so it is beneficial. It makes sure that there's a fair trial. It makes sure that the facts are in order and the facts don't get twisted. So it is beneficial. But to my knowledge, I don't think he ever filed anything of that sort. I don't believe. But that wasn't even his argument about the appeal process, because he never once said anything about the appeal. His whole thing was anytime that the judge would make a ruling that he disagreed with, he would want to say, "Oh, well, I tend to appeal that decision," and it's like, okay, appeal it. You don't have to say it every time you disagree with every particular ruling that I make.
Yeah, but did he have grounds? Oh, I'm sorry.
Grounds.
Grounds. See, he actually just wanted coffee every morning. That's what that was all about.
Yeah, coffee grounds. Yeah. But anyway,
which I've attempted to do, that's been shut down.
That's one motion I've never drafted. I'd have to do some research on a motion limine. I've never draft. I draft motions. I draft stuff all the time. I've never drafted a motion in limine. Never.
I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court.
So there you go. Again, he's saying, "Oh, I'm not allowed to be heard. I'm not allowed to speak my mind." You are, but your rights are not unfettered. Your rights are not absolute in trial. You have to follow basic rules. All because in his mind he has a right to free speech and all that does not mean that he can interrupt the judge whenever he wants and just be a jerk.
Well, it's like these First Amendment auditors. They get out there and scream and cuss and yell at the cops and get in their face and interfere with their traffic stops. And then whenever they get called on, they're like, "Oh, I've got the First Amendment right to do whatever I want." It's unlimited. No, it's
That's
not.
not how it works. It's not how it works. It's not how any of this works. If you know that meme.
Coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down.
Well, there were times, Dr. Dave, where he had an issue with the judge would say, "Can you remove your mask so the person can identify you?" You could just tell he did not want to do that. You can tell.
I think he tried to make. I mean, this was back still during the end, the tail end of COVID, and I think he maybe was trying to use that as an excuse. But yeah, he was trying to hide his identity.
It was that was the thing with the second or okay the second or third day of trial, he tried to make that argument. Oh, the proceedings need to be delayed because I think I have COVID, to the point where he got tested for COVID. What happened was the judge said, "We'll give you a rapid test for COVID." He refused, says he wants a standard test that would take almost a week, trying to delay the trial. They gave him a rapid test, and then the decision came whether he was positive or negative. He refused to give the court the results of his test just to delay the proceedings. And then the judge was like, "All right, the bailiffs will take the paper. You don't have COVID, can carry on." So I think him wearing the mask was like, "Hey, I have COVID, I'm sick," but they forced the trial to go on anyway. And I think that was going to be one of his excuses.
Yeah, he was. A lot of the stuff he did was pretty lame attempts to try to come up with grounds for appeal that didn't work.
Dr. Dave, you must not have followed this trial because you don't know how relevant that statement is about his mama. Dr. Dave, I don't think has any clue.
He definitely needs his mama or somebody. He needs
no, his mom.
I know
that's his mother, because day 16 of trial, the mother, it was like the state was going to subpoena the mother to testify on his behalf.
Right.
His mom, he said, "Oh no, I'm going to tell my mom to come and she'll come. She doesn't need a subpoena." But then on day 16, she refused to show up to court to testify on his behalf, and then made a video statement.
Rocks, I think. From what I remember.
Say again?
Didn't she pretty much tell him to go kick rocks?
Pretty much said, "My son is nuts. He needs help."
Yeah.
Yeah. And that was part of why he was acting the way he was acting on day 16. Like he was just screaming and that's a whole nother video. MC says it. No injured party, while he actually hurt and unalived people.
Yeah, I mean, how many people did he kill? There were 76 charges,
76 in total. I believe he unalived 6 or 7.
Wow. But there's no injured party. Right.
Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right.
Without merit?
I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year.
So, and this is part of where he's contradicting himself. First, he says that you guys are rushing me to judgment because you're not giving me time to prepare for trial. But now he's arguing, not even 5 minutes later, that my right to a speedy trial is being violated because of how long it's taking.
Okay, you beat me to it. I was about to point that out. That's exactly right.
I'm saying, tell me, David, what sense?
No, you're right. He is. He's all over the place, and that's part of the problem. His own arguments are so inconsistent. It's hard to follow what the heck he's even thinking. If anything,
it's like first you're saying that we're rushing you. Now you're saying that we're taking too long.
And he's like a lot of the soft sets though that think they're biased because they don't completely and totally agree with me and are going to do everything I tell them.
Right.
Bias. I mean, no, that doesn't mean they're biased. That means you aren't making a case. And that's really the baseline of a lot of what was probably not just with Darrell Brooks, but with a lot of these guys. They're just they think that fair trial equates to me winning, and it's not the way it works.
Not at all.
I've never consented to waiving anything related to a speedy trial. If that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date, way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's.
And I'll just say something, guys. Speedy trial. Anytime we file litigation, it takes almost a year to get to trial. I'm just being honest. Every case we've ever filed, the firm I'm at, we don't get to trial until 9 or 10 months in. Usually, an arbitration date, if it's a case or an arbitration level, arbitration meaning under 50,000 in the state, it takes 9 months to get a hearing. So the whole, a motion wasn't answered in 90 days, so therefore my right to a speedy trial was denied. No. BS.
Yep.
Clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children to go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time for time.
I never did know
hanging out from time to time watching the game, or.
I mean, you have the number of your employer. I mean, it's like, oh, I can't have the number of one of the attorneys that may go against us in a case. And if I have his number and his grandmother dies and I send him a text, oh, that's a conflict of interest.
Something GJM just said is really interesting. So Wisconsin versus Brooks, the stupid claim is that he didn't hurt anyone named Wisconsin. He tried. That's a very good observation. I hadn't even thought about that. That's good.
Broader Watch says, what would it take to get a successful change of venue? I don't see that there being a
with this one.
venue.
It was denied because this got so much press. You could have had this trial in the Antarctic, and it wouldn't have been. There's no way.
Because of right, yeah. I mean, this was one of those trials that just blew up with publicity, and he didn't like that whatsoever. So, changing venue would not have made a difference. But the judge is going to mention, because his argument is, oh, well, the venue needed to be changed because you couldn't find an unbiased jury, in essence. But the judge is going to explain the length that they went to ensure that they had an unbiased jury.
Which they did.
Or anything of that nature, it would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again.
This trial went on for about 17 or 18 total days. It probably, if he didn't interrupt so much, it probably would have went on like 10 or 11. So yeah, the Speedy trial thing, he's responsible for. This rant, this 50-minute rant included.
He was trying to string it out as long as he could.
Yet he's saying that the court is responsible. That's nonsense.
In terms of when I asked for the motion,
I got to grab something real quick. So I'm going to play it for like 3 minutes and I'll be back.
Okay.
For the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding the fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, correction still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff in the case? So how could the subpoena not be filed? And how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a Detective Facey, that got on the stand and said on the record that it is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor. Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or
Notice, this is his like third or fourth time repeating his same arguments. Oh, by the way, what happened to my certified copies of your oath of office? Which he's already mentioned twice already. By the way, I thought we still have to argue jurisdiction. Like at this point, he's repeating the same arguments. over and
Well,
over.
he also
again.
points out one other thing that's really interesting. Everything, a lot of sovereign citizens do this. They say, "Well, it's on the record, for the record, and let the record reflect." Like that's going to make it true.
Right.
It doesn't make it true. It just because you happen to put it on a record doesn't mean anything.
All it means is it's being recorded. It means it's going to be documented that this is the statement or the allegations or the argument you're going to make. That's all that means.
Yep, and that doesn't mean squat.
And it means nothing. It's completely irrelevant.
I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked.
So what?
You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of the oath of office, but it's not certified. So how can I verify that is the true oath of office that you signed? How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand.
Uh-oh.
So that would mean.
Did you hear that? Did you catch that, David?
What was that?
The law of the land and the statutes.
Oh, well, you got to have statues out in front of the courthouse, and there's a big one in New York Harbor. Yeah, there's a lot of them.
Oh man, what would our world be like without statues?
I know. The statue of statutes.
The final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant?
Oh, that's another one that drives me crazy. Being a public servant, they are public employees who work for the government, who is elected to administer the Constitution and laws of the United States. They are not your personal slave. They're not your personal servant. That ticks me off every time I hear it. They are not your slave just because you happen to be a taxpayer. Being a taxpayer means you get to pay taxes. It does not give you any kind of authority, jointly or severally, about anything to do anything anywhere for any reason to anybody. Exactly. Don't get me started.
Look, for order to say it as a way to demean people, I think he was saying it as a way to say to the judge, I'm superior to you. You do things my way.
Oh, of course he was.
It's nonsense. Absolute nonsense.
You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing.
So you've never seen your name spelled in all capital letters?
Yeah, I think that might have been pejorious right there. Fascinating to say the least. It's perjury to say the most. Oof.
Or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change?
Who cares?
Has no relevance. No legal relevance.
Have filings that have all capital letters.
Or to put it in Brooks's
I say
own
every
words,
time I come into the Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. you bring up Illinois versus Allen, when we had the issue of he being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court.
Really?
You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option.
Yeah, actually, that's exactly. Hey, Will, hold on a second.
Not upholding my
Illinois versus
constitutional rights.
Allen.
I'm sure you know about Title.
You there? Okay. Illinois. Have you ever read Illinois v. Allen?
I have. I've quoted it. I've quoted it on video.
1970, and basically it said that Allen was this guy. Was he convicted of? Was it armed robbery? I think.
Well,
he was
convicted of armed robbery. Yeah.
Yeah, he was sentenced a long time in prison, and he did everything that Brooks was doing. He disrupted the court. He refused counsel. He just carried on. He made all kinds of problems. And the Supreme Court ruled he lost his right to be present. I mean,
he waived his right.
Yeah,
and here's the thing. And here's the difference. Allen was not allowed to be in the court proceedings at all.
His attorneys
at all. But Brooks was put into a different courtroom with audio, video, and was able to participate in a non-disruptive way.
And he could hold up signs that said grounds. So
he was allowed to cross-examine witnesses. He was allowed to testify if he elected to.
He was not barred from the trial. He just was done.
Allen was.
Yeah.
Now people are saying, "Oh, well, that's unconstitutional." One video put a good argument out there where, what if Brooks was an attorney that was equally as disruptive? Well, the judge could sanction the attorney and have the attorney booted from trial.
And he would have been held with contempt and would have had his pile of sanctions on his desk a mile high, and he would have been disbarred.
Exactly. Probably not disbarred, probably suspended.
Suspended, but okay, yeah.
And then once you're suspended, then you have to get back in good standing, which means
it
you can't.
Depends on how long you're suspended. That's why if you get suspended for more than a year, you're in trouble.
Yeah, exactly. But it makes no sense. It just makes no sense. That's all I can say. It makes no sense.
I was surprised he even quoted
USCS 2381
goes against his case,
which states that it's treason.
Well, no. Well, we'll get to treason in a second. No, his argument is that which again is so narrow-minded, that because the case doesn't specifically say be moved to another courtroom with audio and visual, then he says, "Oh, well, that's not what the case says." When the principle is a person can waive their rights to be present in court due to their conduct.
Right. They are
implicitly
waive their right.
Brooks is saying, "Oh, well, the case doesn't say anything about me going to another courtroom." No, because back in 1970, they didn't have those means. There wasn't a Zoom. There wasn't a virtual aspect of a courtroom. Now there is in many cases.
Well, they did have microphones and loudspeakers back then, but even then, that would not have been full participation. You're right.
Correct.
Which states that it's treason not to uphold your oath of office. Treason.
How exactly is she not upholding her oath of office?
You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down.
That makes no sense whatsoever.
Which leads to today. The constant push not to have an informed jury. Not giving legal, valid grounds on objections. Not noting objections for the record to make sure the record is clear. I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing the claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff.
because your questions are irrelevant and not factually accurate.
And ridiculous.
That's clear bias. And it prejudices my defense.
You're right. The fact that you say judge and treason in one sentence, well, trust me, for those that haven't seen this, the opposing side is going to jump on that statement.
How is that not contempt right there? How is that not criminal contempt?
You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for filing in a timestamp when I've seen it done numerous times in just a few seconds, right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait till the next day. That's a clear bias and a clear prejudice to my defense.
No, it's not.
Obviously, the court knows that I'm not privileged to the same filing system.
No, you're not.
Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel.
It's assistance, not assistance.
And that's
now,
not what we do.
Something. I want you to understand something. He's saying that the Constitution doesn't say anything about people not having assistance of counsel. What Brooks wanted was a paralegal. He wanted someone like me to sit there in court next to him, do all the pleadings, do all the filings, set up all the discovery, all that, file the subpoenas, contact witnesses, whatever. But he would be the ones making the arguments in court. Guess who does all that? An attorney.
Mm-hmm.
That's
what
why
he wanted was somebody to do the what he wanted was somebody to do the grunt work and not tell him he can't do that or this or the other thing.
And you know what? I'll tell you something. You know what I blame? I blame media for their portrayal of the judicial system and pretending like that's common. If you watch Law and Order, every time someone says, oh, they're representing themselves, the judge is like, oh, I'm going to have so-and-so be standby counsel to help you through the ropes. That doesn't happen.
Right.
As common as the media says it. So he probably watched us like a couple episodes of Law and Order, but there's a couple of good Law and Order episodes, SVU episodes where that has happened. People have represented themselves with quote unquote assistance of counsel, and they've won their case. That's probably what he was going for, but that's not how it works.
At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement. But yet, I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, And per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day, not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be, at least in some form, general population with upcoming trial.
He would not have survived a day.
Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look at certain case laws? How can I do any of this if I don't have full access to it?
I don't think, and I don't even think that's. I don't even think that's factually accurate. I'm sure that if he were to request, I need time to work on my case, they will give him the resources needed with supervision. Like he could probably go to the library, more than.
But you know what he would have said if he tried to have any supervision. Said, "Oh no, they're going to tell the other side everything I'm plotting."
I mean, he did accuse the prosecution, the state of coaching witnesses. So that is true.
I even suggested some type of order that can be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple of days to prepare for a trial of this magnitude.
If he thinks he only had a couple of days to prepare, he doesn't know what he's talking about. Why did he think he was in jail for a year before the trial?
Right. And the thing is, and here's the thing, I don't think he's making a bad argument. I think it is reasonable to say, look, I know I'm in a strict protocol, but I need more time practically to work on my case. Allow me to have the resources I need. And again, they have plenty of bailiffs. They'll have a bailiff accompany him to the library, make sure that he's in the library working on his case 2 or 3 additional hours a day. You know what I mean? Like that's not an unreasonable
he would have
request.
argued. He would have said, "Oh, but I'm not. I don't have time, so I can't prepare my case."
I understand that. He's trying to say that the court is making it preposterous that I would recommend that, even though it's actually a legitimate request. That's not the case at all. And as the judge will say, he never once the prosecution will say he never once requested more time. He has tools provided for him to help him with his research, which will be mentioned shortly.
Well, at this point in the trial, though, he was just kind of flailing for anything that would work.
Right. He's 2 weeks. At this point, this is day 9. So he's 2 weeks in. So
he knows he's going down.
Change the video again. Even now with y'all going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to trial.
I wonder why.
Hate mail comes from people right here in the city of Waukesha, which gives more credibility to the venue needing to be changed.
Does he not? No, it doesn't. It's the exact opposite.
Yeah,
it's evidence why changing venue wouldn't matter.
I mean,
he's that stupid. He doesn't realize he's arguing that proves that the venue needs to be changed, being that it's a global and the international. He's getting international hate. No, you're proving why the change of jurisdiction doesn't matter.
You could go to Mars and you're not going to get a fair trial,
according to him.
This guy is a trip.
It's impossible for impartial jury to be found in this county, and that's not discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That would be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer
Hey, David, what is that? What is he's saying that the live streaming platforms have a comment section where people say insensitive stuff?
No.
I guess what that's covered under.
I'm shocked.
Guess what that's covered under.
Wait, but you mean live streams have comments that are rude? Oh, I'm out of here.
And guess what that's covered under?
Oh, that pesky First Amendment thing, right?
That pesky freedom of speech.
Yeah, don't you hate it when that happens? Oh,
God dang.
Terrible.
It's sensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is that I have children too. Family to loved ones too.
Oh.
But you had no regard for other people's families.
No kidding. You didn't mind whacking out a bunch of other people's families, you scumbag. Sorry.
No, you're that's exactly that pissed a lot of people off when he said that.
Yep.
Mind you, I was watching this live when he was saying this on one of the live streaming channels, reading the chat because I was at work and I'm reading look at the bailiff behind him. The bailiff behind him rolling his eyes. Yeah.
Man, that's got to be a tough job to be a bailiff in one of those trials to keep an air of impartiality.
Especially this one because his facial express. He's sitting behind Brooks majority of the trial, and you just see his facial expression when Brooks says random stuff. My dad and I were watching this one day. My dad's like, "Oh, that bailiff behind him looks like he wants to choke him," and I'm like, "Yeah, he does."
I can't imagine anybody who would have convicted him for doing
it.
Loved
ones too. They also have been ridiculed and have their necks drugged to the mud and have threats towards them. Loved ones that have to leave their home because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever.
Is he talking about his own kids?
To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive.
Yeah, well, so was running over 70 people.
Definite tragedy. Definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about.
Well, what else did you do that we don't know about?
And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive and it's not true. I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions. I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied. Without any validity. Zero. There's so much bias that's going on that even with all this, for the record, we still have no proof of jurisdiction. We still
that's the they've got your butt in jail.
That's the fifth time he's mentioned jurisdiction.
Mr. Brooks, your butt is sitting in their jail. It sounds like they got jurisdiction to me.
We still have no plaintiff. We still have no claim. We're not sure.
It's funny. He probably would still be talking now if the judge never stopped.
Yeah, you know, one of the things that I found really interesting. Do you remember when the sentencing came, when he got sentenced? Darrow could finally not keep up the veneer of impartiality, and man, did she let him have it or what?
Especially when she removed him, because he started to interrupt her when she was going through her sentencing, and then when she removed him to the other courtroom, then she had then you could tell that she took any filter she had off.
Because I mean, I can imagine after however long it was with this guy, she was I will eternally respect her patience, because that just I could not have heard this case. I would have
you would have lost it. Yeah.
Of the relationship between you, Your Honor, and a father of one of the people that was in.
Was that song "Even Caught Me on Camera"? Wasn't me. That's funny.
We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious. Where's the proof? I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in
outcome of this case? She has no obligation to give you an affidavit about anything.
There's no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 15 minutes to make your various arguments.
Because she couldn't listen to him repeat himself over and over and over again.
Now she finally had enough of this.
All right. And what I want everyone to do is direct your attention, because the judge isn't even going to respond. She's going to let the district attorney handle this to start. Listen to the district attorney in her response.
You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have a response. Go ahead.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 304590.
Can you repeat that last?
I'm so sorry. 3045190. Retzloff versus Moran. This case.
Oh, I want to say, look this case up, guys, if you're interested. The case that she's quoting. Because they have other cases in different states that are similar, where it talks about how these pro se litigants will just start spewing this random mumbo jumbo, which makes no sense whatsoever in court and has no validity.
Yeah, Retzloff versus Moran was a Wisconsin case.
No, absolutely. Absolutely.
This is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states, the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. The court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly.
You call that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court.
At that point, end of story.
Yep. Patiently went through the form and advised him of many of the things he's complaining about here today, the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful.
That's a very valid point. That's not a word you just throw around in court.
Or anywhere else.
Of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know.
And that's something that that he neglected. He's pretending like he's sitting there. If you watch the trial, especially for the first few days, even though his cross-examination wasn't effective, he demonstrated that he not only had the ability to cross-examine the witnesses, but if he had a little bit of legal training and understanding, he probably could be successful at it. Remember, guys, I don't believe, and people make jokes about it, I don't believe that Darrell Brooks is an idiot.
He's not
I don't
stupid.
believe
He's just crazy.
Listen, here's the thing. If you listen to him, his long rant, even though he can't pronounce words, he's relatively well-spoken. If he was he could be an excellent public speaker, I believe. I'm just giving him his props, you know? If he channeled himself to that, maybe. And again, like, he was able to cross-examine witnesses effectively in a trial that he, quote-unquote, had no time to prepare for. Now, there are some people that they're naturally gifted like that. Like, there are people in school, they don't have to, really do a heck of a lot of work, and they still get good grades. They're able to just kind of wing through it. There are people like that. But his argument is, I'm out here, not able to defend myself in a trial at all, when he's in a losing case. If this was like, if he went to traffic court over a ticket, I think he would have a decent chance of representing himself. And I know it's traffic court, but still, it's just not in a capital murder where you murder.
It's probably not the place to try.
Yeah, but say it's not the place to try.
Because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to the trial, and on the other hand, we're rushing him to this case, and he hasn't had.
And that was the one thing that drove me nuts. I'm so glad that she said that, because I remember watching this live and I'm like, you're saying two different things. And you can tell she's fed up. Like, you just look at her, you can tell she's just, hold on. You can tell Attorney Opper's just completely
It is right because it's taken us so long to get to the trial. And on the other hand, we're rushing him to this case, and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not confuse. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to.
Well, that's huge. His whole argument is, I'm locked up, so I can't prepare for my trial.
Yeah.
But if he has access to a computer and a tablet,
yep,
whenever he wants to prepare for his trial, that tells you a lot.
I'm betting they probably didn't even supervise where he went on it, because they can't really, if he's preparing for trial, it's not up to them to say where he can and cannot go on the internet, which would be very unusual.
Well, no, I disagree. Probably limit websites. They probably can't get on Google. I mean, they have, they monitor internet usage. They probably have
Yeah,
blocked
but there are
certain
some
number of
limitations
websites.
about what they can block if the guy is preparing for his own trial in a pro se case. I would imagine. I have to look that up. Actually, that's interesting. We have to.
No, that's a good question, really.
Yeah, I'm not.
I mean, like you can't go on like adult websites and watch adult films, obviously. Like, yeah, that type of stuff will be blocked. Maybe you could go on Google, but they primarily are going to want you to use the court's websites or the research website, probably stuff like that. That's what I assume he'd be limited to. But you're right, there could be other limitations lifted.
Yeah,
for
you can
that
get on
reason, because
Westlaw, Southwest, Southwest 7, those kind of things.
yeah. Lexus, he referenced Lexus. Like, yeah, those obviously they gave him access to that. So
yeah, he wouldn't probably
Ask
know
for those.
how to use it, but
well, what Lexus to me, Westlaw is better than Lexus. I've used both. I prefer
Probably
Westlaw
too.
over Lexus. But yeah, that's just me.
Resources is up to him. I would also cite the court to U.S. Ex-Rel George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again,
There you go. That's it right there.
and you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him.
The poor jury has to stand. Probably been standing the last hour waiting to come back
yeah.
in.
So now what? I could just.
And said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Bookie worm. It's AI generated. I have no control over that. Someone asked earlier for closed captioning and I put it on. I don't usually use closed captioning unless someone puts it on their videos, like does it manually. It's not ever good. It's never good. So I'm sorry that it's atrocious. And how do you know that, young lady? For all we know, they've been standing this whole time. Sheesh.
Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now.
It's not crap because look, I'm not a lawyer. Forget about even the fact I've worked in the legal sector for 4 years. I'll just be honest. Everything that she just said is spot on accurate about all of his accusations.
Gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not going to hold you up from what you're going to say, but that's a load of crap. For her to sit there,
Mr. Brooks,
for her to sit there,
objection is noted.
for her to sit there.
No, it's my turn. Let me go through this. I graciously.
I'm not. I'm trying to look. I'm mentioning I'm compassionate for the jury. I feel bad for them. I'm not. Come on. I know they weren't in the room. I assume like they took him outside, or did they take him back to like the room where they all sit in? Like, I hope not. I hope so. They've had to be away for so long.
Gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I'm going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaint about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity to the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred, the state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. And then there was the hearing.
Point being, we as the court went above and beyond to ensure that no one on this panel of jurors would be biased in any way.
They really called 1,400 people for this jury pool? Wow.
Yeah. Well, so and David, that's ludicrous.
Yeah.
On a typical day, how it works, they'll cram, I don't know, I'm just thinking about how they do it here, 80 people into a room, and they'll say, look, this is going to be a murder trial. Does anyone have any conscientious I sound like Darrell Brooks. Does anyone have any problems sitting in on a murder trial? 50 people raise their hand. You guys can go. All right, let's move you guys to a smaller group, and then we'll ask you individual questions. Do you know the plaintiff? Do you know this? You know that. So, like, that happens on a regular basis until you find jurors that fit the criteria that you're looking for. 1,400 people? 1,400. And you're going to say that they couldn't find 8, 10, 12, 14 jurors that were unbiased? That's such a bad argument on Brooks's part.
This court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges.
I believe the only way she had the patience that she had was because she has children. Because this was like dealing with a grown child.
You're right. It's pretty childish.
Like she probably has 2 toddler boys at home that she has to wrangle with every day.
Well, and the bigger picture though is that they're childish, yes, but this is what most sovereign citizens are like. This is how they think. This is how this is exactly what the problem is with most of them. They don't.
Even if they don't think that way, these are the arguments that they make in court. There you go. You just affirmed it. So those are the arguments that they make in court. That is the way in which they try and conduct all of their legal proceedings, whether or not they have validity or not, whether or not it's successful. And all it is, as this has been the last 50 minutes, the 2 hours we've been streaming, is a waste of everyone's time. This should not have happened. I know some judges we've been before, and for me with working, 5 minutes and this would have been shut down.
Well, and part of, and I understand it was a high visibility trial, and she, everybody had to watch their P's and Q's make sure there was nothing, appealable later. But this is a classic. This is going to go down in history as what's wrong with the sovereign citizen movement. It's just,
It has.
Really.
I'm surprised that it hasn't been covered as much as it has by like anti-art or sovereign citizen channels. I'm waiting for someone like Van Balen to really to cover something like this.
Yeah.
I know this is about 2 years old, but still, it's equally as relevant just because of how much attention this got.
Well, and it's the violence and just the whole horribleness of what happened is also part of it. And that's
correct.
But yet here's Brooks still arguing, where's the injured party? They're lying all over the street in the Waukesha. That's where the real question is, well, you can't get me because I'm me and I'm innocent because it's me. And that's really kind of how that their arguments that they make. If you disagree with me, then you're wrong. You're not upholding your oath. Yeah. If you are against me,
no, your oath, not oath.
Excuse me, oath. Yeah,
oath. let's just play on to the rest of what the judge has to say. Then we're gonna wrap this up.
Extra for the alternates, which would be 7, but out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise, and then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive, they come to this court. As the case law says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments.
Do you remember how long did it take them to come back after they started deliberating? Do you remember? It wasn't very long, was it?
I think it did take overnight, but that was simply because there were so many counts. Remember, there were like 80 counts in this case.
76, I think.
No, but there was a couple of additional.
Okay.
Well, but no, there was like domestic stuff. I think it was like 81 or 82 counts in total. There were 6 for murder, and then like for the assaults of everyone else that got injured. But there were like a couple of other smaller charges that they had to come back and rule on as well.
Okay, that's right.
But I think, and I could be wrong, but I know it didn't take. Like, if there's 80-something counts in a case, sometimes that can take days for the jury to come back. They either came back late in that day or early the next day. One of the two.
I remember watching it. I remember thinking it wasn't very long.
Yeah, it wasn't that long. Oh, KC the expert, 3 hours.
Thank you, Casey.
Well, 3 hours for 80 counts.
Yeah, I think
they were all on the same page. They were like, come on,
half
guys.
of that was probably over. Half of that time was arguing over what to have for lunch.
Exactly.
And complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issue raised, for example, regarding subject matter fiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact. The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true, you have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted, the record is going to be very clear. All right, I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you want to change your plea in this case and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised, or there is a valid claim for that, sir, it's not been raised in the proper way before this court.
The original
this
judge
trial will keep going.
The original, she's not, that's what's so funny. She's not the original judge in this case.
I didn't know that.
Because the judge that recused themselves had an actual personal relationship and emotional tie to the incident. So,
I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum. And that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raised concerning your right to assistance of counsel, the record before this court over the many days that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, a bill of particulars, regarding contracts that you entered into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course.
Ah, boy, oh boy. You guys, you know who this is? This is probably one of Flex Your Freedom's friends. One of the people that was threatening to come to my house.
This?
Listen. Hey, buddy, listen very carefully. I stream 2 to 3 times a week. This is my first time in 9 months, maybe 10 months, I'll say, streaming about Darrell Brooks, because this is what I wanted to stream about. Guess what? I made that the title of the stream, so if people weren't interested, they didn't have to watch it. But you want to come here and make your stupid remark.
What a zero.
You know what? Fuck off, dude. Excuse my language. Get out of here. I don't have the energy for this. I don't have the energy for this.
Has been out for quite some time, so I'll instruct Madam Clerk to bring the jury out.
You didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof.
The issues are irrelevant. And again, the judge and the prosecution cooked this guy.
That's true.
We're going to wrap
I think this
stream
was
up.
interesting just because of what it says about the sovereign citizen movement and First Amendment auditors and all those guys. And it really shows how outside the law they are, or outside of the understanding of the law anyway. They just don't get it. They're idiots. When you get right into it, they don't understand the law. They don't understand. They think the law is only effective if they are the ones who benefit from it. You know, it's just, I don't know.
It is what it is. So here's what we're going to do. To wrap this stream up, let's have a look at an infamous video. Darrell Brooks not getting his way in the second courtroom and building a box for it.
Oh, yeah.
Bail could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but...
Mind you, and he's throwing documents on the floor. The judge said, look, the bailiff is providing documents that you claim you don't have. Well, I don't have them. The bailiff puts them in front of him and he throws them on the floor. I still don't have the documents.
Gee, I wonder why.
Like, what a shocker. I wonder why. Maybe because he threw them.
It's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70.
Him being ignored is killing him. He's like, you know what? Forget
I
this.
want to do that.
Like a parent ignoring a child that's on timeout. That's literally what's happening right now.
76. The 76 count. Just want to
Watch this right here. Watch this right here. This is the funniest part.
I remember
that was
this.
just one question I had.
Couldn't even lift the box. He's a big tough guy, but can't even lift a 20-pound box.
So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
Exactly, Bookie Worm. All they want to do is debate, which is what he wants to do, and the judge just isn't having it. And if you watch, it's funny looking at the fact that he has a box for it up, but if you watch the actual tape of this, this goes on for like an hour and a half. He puts this box for it up twice, but he's literally screaming at the top of his lungs at the bailiffs, arguing with them while the judge is going on in the court proceedings, and he's not listening at all. And then he goes back to, oh, well, I was arguing because I didn't understand you. No, that's not the case whatsoever.
He was just too busy screaming at people.
You see him talking. You see him being animated behind those boxes. You see his forehead, how big it is.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom.
Oh, is this one where he starts stripping because he can't go back to his cell?
Soon. I mean, just look at him. I mean, look how pissed off he is because no one's listening. He's like waving his arms. He's like, I don't want to even look at the judge. Look at this.
He got into some serious stare downs with him too, with Judge Darrow.
Would you want me to end the stream with that? The
That's
infamous
okay.
one?
That's okay. This is pretty good.
You can see him yelling right now. Look at his head. Look at his forehead bouncing.
Has anything? Have we heard anything about his appeals? Were they all rejected?
Well, no. So, see, this video went longer than I expected. I wanted to watch the Erica Patterson trial. They had that trial, and he was found guilty, which he's literally crying like a baby the whole time. But no, there's no word yet.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
Probably a good thing.
Yeah. But as you see, he puts a box fort up, and the judge is treating him like a child, and he does not like it one bit.
Maybe that's because he's acting like one by building a fort.
Hold on, can we here? Let's.
You know, I'd ask that it be put in writing.
Let's fast forward to right here.
Any additions, corrections, edits, or deletions.
The box.
Your Honor, would it be possible for the bailiffs to just move the boxes off the table? So
Yes, I think that's fair.
So now the child is like, okay, Daddy's coming in to move the boxes from your box fort.
I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there.
Hopefully he's not having that wank.
Let's hope not.
Imagine, dude just jerking off behind the boxes during a live trial.
Everything else happened in this trial.
If you could move the second one because it can interfere with the microphone as well. And the third one. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
So what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
you have any requests
First of all,
related
what?
to the jury instruction, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though, because
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
That's right, guys. He's screaming like that. Not at his dog, his sister, not even his mama.
At the judge.
He's screaming like that to a judge
who has his entire future in her hands.
Yeah, he's so stupid to realize that.
Wow.
Now let's 1 second. Let's fast forward to where he does it again.
Requests as it relates to the jury instructions. I'll unmute you for that answer.
I can't hear everything you're saying.
What do you call that, David?
Insanity. I'm not sure what anybody else would call that.
You have kids, right, David? You have kids, right? So what if a child did that? What would you refer to? What would you call
temper
that?
tantrum?
Let's have a look again.
That answer.
I can't hear everything you're saying.
If my son did
Little
that,
pouty stomp in the corner when mommy says no.
If my son had done that when he was a kid, that would have been called grounded for a month. Is what it would have been called.
Well, let's fast forward now. After Darrell Brooks has multiple temper tantrums with the judge, what he does next.
150.
And this is going to end the stream.
Is the one
Review instruction either. That was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document.
This? I'm going to cut the volume. David, is he building another box
I think
fort?
so. It looks like either that or a snow fort of some sort that we don't know about.
He's a snow fort. So after the bailiffs took the boxes away and the judge specifically took his toys away, they brought them back and said, keep them here. Do not build another box fort. And what is he doing?
Building another box.
Building a box fort in court to hide from the judge because he's not happy with her putting him in timeout.
This guy, I guess I didn't appreciate how crazy this guy really was until this now. He's really nuts.
Right. Now let's see how the judge responds when she notices this a minute or two later.
Table, but they need to be moved off to the side. And Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials
they have
related
nothing to do with jury
instructions,
instructions.
he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
One bailiff. Look at him looking down. He won't even look at her. About that one bailiff. Keep moving all the boxes.
The verbiage of jury instruction 70 on page 65.
No question. Are you my accuser?
Yes,
All right,
actually.
he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this.
It's amazing how he seems to think that the judge works for him somehow or another.
Well, I mean, frauditors say the same thing. You're a public servant, which means you work for
Which
me.
I said before. No, they're not. They're public employees who work for the elected officials that we, the people, who none of those people represent for a second, elect at elections, who are there elected to run the government. That's who those people work for, not somebody just because they happen to be a taxpayer. We're all taxpayers. Unless you ask Wanda Mike, who doesn't think anybody who works for the city or the county is actually a taxpayer since they get paid with tax funds. But we'll not go into that one right now.
Violet Rose puts it perfectly. What's confusing is these people, Darrell Brooks, want others to take them seriously, but then continue to act like this, like a child.
Exactly. They're. I mean, it's like what kid? I mean, think about the kids. Some kids. I think about the kids in the place I teach, which I teach a disciplinary campus, and that's how a lot of them act. They want attention right now. They want attention this way. That we're going to do what I want because I want to, and that's what we're going to do, and that's that. So there, yeah. That's exactly how a lot of these sovereign citizens act.
Total nonsense. So we have the stream keeps going longer and longer, but you know what? Let's keep going another couple of minutes. Let's have a look at him scream at the judge for no reason.
Mr. Brooks filled out a subpoena for Don Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks
Is that his mom?
Iverax is still here.
Is that his mom?
We had subpoenaed her.
Don Woods, yes.
Subpoena.
And she's the one that he's. Oh, well, just listen to what he says.
So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Ms. Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I wanted her to be here, she gonna be here.
I agree with
So
the
just
state
know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
So Dr. Dave earlier said, does he need to call his mama? But literally he claims that his mom was going to show up based off of his command. But then she never comes because it later comes out the mom refused to come because if he had subpoenaed her, she would have come. But because he told her to come, she refused to testify.
I don't blame her. I mean, if she.
But he had that arrogance. Oh, well, all I got to do is come.
I'll
Tell
tell
her
her to come. She'll be here. Yeah. I know.
Let's just, if you don't mind, David, play the next minute and a half of just the fireworks, and let's just let everyone take it in.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her here at 9 a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a judge?
Brooks, I need to make a record of
I need to make a record, too. When am I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to make.
I'm gonna give you what you know is coming.
I need him to go to the other courtroom because I do need to put some things on the record. The record should reflect
the contract between you and I?
Mr. Brooks
if it's
is
criminal,
yelling at me.
What is the crime?
He is.
Who makes the claim? And what is?
I will make the record when we get back. I will step off, but Mr. Brooks, you're being taken to the next courtroom.
Mr. Brooks, don't try to address me like that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tactical agreements, being biased, judicial misconduct, trying to steal somebody's.
That's a new legal term I hadn't heard. That was cool. Is that a legal term that I don't know about?
Wow. I don't recall a judge ever indicating they were cool.
Yeah, that's
wow.
Something else.
What are your thoughts on that?
I can't imagine that. I can't imagine why he lost this case. Well,
and remember, the judge was the one that sentenced him, so you would think he wouldn't act so arrogant.
Yeah, well, he does. I mean, One thing that was clear from this trial is he did not get that it was reality. I mean, of course, I don't think he got that it was reality when he ran all those people down either.
He did not. And that's the point. It was like an out-of-body thing that, again, the thing with Erica Patterson where he was found guilty of domestic battery, I believe it was.
Yeah, it was.
He was crying and bawling in court, trying to show all this sympathy. But he shows zero sympathy in this case, only when it came to him being held accountable.
Yeah, and that's a big part of the problem with all these guys is that, it's okay if everybody else is held accountable, but when they have to answer up for they're usually the ones committing most of the crimes.
Exactly.
Hypocrisy, thy name is sovereign citizen.
Mm-hmm. Rules for thee, but not for me. Let's have a look again at Darrell Brooks exploding in court. Early in the proceedings, but still. I find it equally as satisfying.
Mr. Brooks, the live stream is on.
I don't care about no live stream. Just like y'all don't care. All this political, this the show. Y'all being told to
Mr. Brooks.
getting paid.
Mr. Brooks, look at me for a minute. Mr. Brooks. Mr. Brooks,
You
look
sit
at
here and act like you know me. People like you don't. Y'all
Mr.
you don't
Brooks.
know nothing about where I come from.
Mr. Brooks.
You push me, dog.
Don't push back then.
Mr. Brooks.
Don't push back.
Push me again.
Mr. Brooks, we have to continue with this hearing.
Want to talk to the judge or not?
No, I'm worried about, man. Don't put your hand on me, dude.
Nobody put their hands on you.
They better not put their hand on me.
Okay, Mr. Brooks, you need to look at me for a minute, okay?
Why? To listen to all this political stuff y'all got going on?
Mr. Brooks, I'm more concerned about...
Stay seated.
All right, we're going to take a break and we're going to come back after lunch. I'm not going to do this with him right now. He needs to be here. He's not cooperating. I'm going to give you the warning, Mr. I will give you the warning that if you continue to interrupt when we go back on the record, you will forfeit your right to be in the courtroom today. I can't have these interruptions. I want you here. It's been a long day and a half.
Keep your hands off me.
We'll come back at 12:30.
Just hold you get off me.
Wow. That's unbelievable.
Bookie Worm says it perfectly. He's talking gangster now. The real Darrell Brooks.
We're getting a glimpse at the real guy there. You're right. He's showing his colors. I mean, that's just...
Honestly. I didn't think the stream was going to go 2.5 hours. Otherwise, a couple other people wanted to come up. I said no. I thought we were only going to be here for like an hour. I'm surprised we were able to stretch it this long. There's so much with this. I know there's an idiot here saying, oh, you're playing old crap. It's still mind-boggling to me. And it's something that needs to be studied and discussed even more. But David, I'm going to drop you backstage.
Okay.
We got to wrap this up ASAP.
All right.
Thank you for coming on. I appreciate you, bud. Talk to you soon.
Talk to you soon.
All right, everyone. Let's wrap the stream up. Have a good night.
Now, everybody say goodbye for about the 7th time to the newest Frauder Mania YouTube handle he has created. Go create you a few more, because Eagle Nick Audits is fixing to send you out the door.
Oh, what an assault.
Fuck you up. Say my mom again, bro. Say my mom again. Say my mom again, bro. Say my mom again. Say it again, bro. Say it again. Get the fuck out of here. Fuck out of here, boy.
Are you serious right now?
Let's go.
Don't you touch me. Don't you put hands on me. This is a lawsuit, sir.
Okay.
Everybody see what's happening? Look at this.